This is a part Holgate Hill and the Mountain of Adriatic Land Island and the Leaseholders at
Mr. Loveday. During the course of the morning, I'm going to first of all deal with the respondent's analysis of the two principal provisions, paragraphs 9 and 10, and how we say they fit together. Secondly, I'm going to deal with retrospectivity generally, which will take up, I suspect, the bulk of my submissions. And then thirdly, I'm going to deal with explanatory notes. I have, in my skeleton, dealt with taking it back one stage further as to the basic structure of service charge covenants. It's familiar territory, I'm sure, that a service charge covenant will generally have three elements to it. The first will be an explanation of which costs a landlord or a management company can apply to the service charges. Those are, in statutory terms, often referred to as relevant costs. So I'm going to come back to that in a moment. The second element is you apply an apportionment, a percentage, a fraction, and so on, to arrive at the service charge proper, the service charge being the lessee's obligation to pay a sum of money, a contribution towards those costs. That is generally, in statutory terms, described as a service charge. You can see this pattern going all the way back to the 1972 Act, which is in the Hippersley Authority bundle. And if I can start with that, the original controls under the 1972 Act were light touch. I don't need to take, in fact, they only required certain information to be provided in respect of service charges, but you can see...
Sorry, I think I'm looking in the wrong place.
Yes, it's...
I was going to call Authorities Bundle, but it's not that, it's Authorities Bundle 1.
Yes, it's Hippersley Appeal Authorities Bundle.
Yep.
And page 6, one can see right down at the bottom of the page, there are definitions which I don't really need to take you to, of relevant costs and service charges. But more importantly, when the legislation was consolidated, those two terms found their way into Section 18 of the 1985 Landlord and Tenants Act, and in fact both of them were brought together in one provision, so that a service charge had to vary according to the relevant costs, and so they were brought together. And that Section 18 definition, I think we've handed that up loosely at the beginning of yesterday.
Yes.
One can see that those two elements are there in Section 18. In terms of the statutory restrictions on the recovery of service charges, the legislation, particularly the following provisions in Section 19, Section 20, Section 21, and so on, focus on one or other of those. So they either restrict the recovery of relevant cost contributions, or they have a full-on restriction on the service charges themselves. When it came to Schedule 8, it's been described as a self-contained code. That's the way it was described in the, or certainly Part 5, was described as a self-contained code with its own bespoke service charge provisions, and we have restrictions which obviously we've been considering over the course of the last day. Interestingly, Schedule 8, paragraph 9, in common with the previous provisions, so that is paragraphs 2 to 4 and 8 in particular, They simply refer to a service charge. There's no reference in those provisions to relevant costs at all. As a result, one might ask how one could easily, therefore, apply the consequences of those to issues over the recoverability of service charges. And the answer to that is provided for in paragraph 10.2. So one turns to paragraph 10.2, which you have loosely or in the core authorities at page 78. One can see there that it says this paragraph supplements paragraphs 2 to 4, 8 and 9, where a relevant paragraph provides that no service charge is payable under a lease in respect of a thing. Slightly awkward phrase there, thing, but I think we have the gist, the relevant paragraph of Schedule 8. No costs incurred or to be incurred in respect of that thing or in respect of that thing and anything else are to be regarded for the purposes of the relevant provisions as relevant costs to be taken into account in determining the amount of a service charge. So what paragraph 10.2a(1) does is it brings the consequences of Schedule 8, paragraph 9, into the conventional service charge statutory machinery by adopting the terminology that gives jurisdiction to tribunals to determine liability to pay and so on and so forth. And that element was described in the Upper Tribunal as the machinery, which is why the Upper Tribunal concentrated on the terminology used in paragraph 9 as opposed to the machinery. One might ask, I suppose, why it was necessary to provide anything there in terms of machinery, given that paragraph 9 had already referred to service charges, which is a statutory defined term. In my submission, the answer to that is the second element of 10.2a are to be met from a relevant reserve fund. And the situation here is that payments out of a reserve fund are not generally taken to either be a relevant cost or a service charge. And so payments that are made out of a reserve fund by a landlord, they may well be subject to a statutory trust, but apart from that, they don't readily engage any of the statutory controls over service charges. And it seems that the draftsman had in mind that in the case of major building works, remediation works, there might be a large pot of money sitting there that had been paid in by way of into a reserve or a sinking fund that could be applied to the remediation works. And therefore it was necessary, or it was thought necessary, to provide for some control over landlords simply deploying that, spending that money on remediation works without any kind of control. And it's very difficult to actually word a provision which provides for a reserve fund without distinguishing it from a service charge or a relevant cost, which is why you may well feel that they've spelt it out in no uncertain words in paragraph 10.2a. It has, in a sense, 10.2a is about reserve funds, not about service charges, but it's there and it provides the machinery for plugging in to the existing legislation. So,
does that mean leave aside these costs. Other costs, landlords can just spend unreasonably large amounts out of reserve funds with no statutory control.
Well, the control is on the monies paid into the reserve. So it's the contributions that are made into the reserves, because those are treated as relevant costs. When it comes to expenditure, there is certainly some debate as to whether landlords are bound by any kind of control, it's in my submission it was an obvious difficulty, which is why it was dealt with. It's an area of uncertainty at the very least.
Can I just see if I've caught up with you? Section 18 tells us of the 85 Act tells us what a service charge is and introduces the concept of relevant costs. But it's just basically scene setting, giving you definitions. Yes. If you're looking for a mechanism which imposes a control, you go to section 19.
Well, in my submission, to
start off with.
Sorry,
section 19, if I misspoke, I apologise. Section 19 tells you that relevant costs should be taken into account in determining the amount of a service charge, only to the extent that they're reasonably incurred.
Yes, that focuses on. I said that some controls focus on relevant costs.
I'm trying to simplify it for my purposes. When you come to paragraph 10, it's doing something different. It's actually saying certain costs are to be stripped out. You don't apply the reasonableness criterion at all.
Yes, but it enables in my submission, what it does is it returns
uses the language of relevant costs.
Yes,
obviously, but you don't bother to go through section 19 and ask whether they're reasonably incurred. Parliament says, insofar as it applies, they're not to be taken into account.
Yes, but for example,
it's very straightforward.
For example, the jurisdiction on under section 27A depends on fulfilling those tests as well. So, for example, it would give the tribunal the jurisdiction to. It's a way for the tribunal to have jurisdiction over those costs. But I see the force of your lordship's point. Our simple point here, starting point, is that one doesn't look to paragraph 10.2 to see the temporal restriction, if I can put it that way. It would be because, as has already been explained, when it comes to conventional service charge controls under the 1985 Act, there's no limitation period. One can go back as far as one wants, and certainly on an application by a lessee. And so that doesn't provide any temporal limitation at all. One has to look to paragraph 9 itself, and we are essentially supporting the Upper Tribunal's analysis of the provision to say that it is a simple provision which provides that if a service charge is for legal or other professional services relating to the liability or potential liability as a result of a relevant defect, then no service charge is payable, and there's no restriction on time there at all. There is a slight gloss on all of this in terms of the wording used, and that is to note that paragraph 9 itself again doesn't use relevant costs. It creates a new expression to deal with what would otherwise be considered relevant costs. It talks about service charges being payable in respect of legal services, etc. And the Upper Tribunal tried to find an expression that wasn't the words relevant costs to explain what those costs were, and it came up with the expression qualifying services. But one might ask oneself, given the the references in paragraph 10 to relevant costs, why the draftsman didn't simply say relevant costs in paragraph 9. And in my submission, that may well indicate that the draftsman wanted to get away from any kind of intermediate step that depended on timing, and that it's simply closely bound the cause and effect, if it's a legal or professional service relating to liability, etc., that no service charge was payable, and that avoided the need to think of intermediate steps. And against that background, one has the purpose of Schedule 8, and in part we derive the purpose of Schedule 8 from the explanatory notes, and I appreciate that there is some discussion about the role that explanatory notes take, which I'm going to come back to. But we say that that certainly in terms of explaining the purpose of Schedule 8, it's entirely material, and the explanatory notes talk about historical building defects and protecting leaseholders from the associated cost. So we say that in terms of interpretation, there really isn't any ambiguity. That's the way that the provision works, and that it's not limited in terms of time. Now move on to retrospectivity.
Just before you move on, it's apparent from the material that's before us that the policy intention was that leaseholders shouldn't have to pay any more after the Act came into force, but those who had already paid service charges wouldn't be able to get it back. How does that fit with your interpretation? Because what I took from yesterday was that if there's no temporal limitation in paragraphs 9 and 10, there's nothing stopping leaseholders who paid service charges in respect of legal costs 25 years ago from applying under 27A and saying that's not payable and I'd like it back.
Well, obviously, there are various conditions with Schedule 8 as to the type of works and so on, the type of expenditure that apply. But we don't balk from that. We say, for example, that's likely to be the consequence of Section 124. There is a case which was referred to. It's a first instance decision, but it's by the president of the Chamber President of the First Tier Tribunal, called Batish. It was referred to below in the Upper Tribunal, where that provision was relied upon by leaseholders to recover service charge contributions that had fallen due before the Act had taken place. So it was referred to. I'm not suggesting it's binding on you, obviously, but it's an indication that it's a pointer that Section 124 enables leaseholders to use the provisions and to go back before the Act came into force.
So just to be clear, picking up Mr. Allison's submissions, do you accept that it would be open to a leaseholder to challenge an entry in 2006 account relating to fire doors, and on that basis either to ask for money back or have consequential adjustments all the way through to now in the service charge accounts?
I would certainly invite that as the proper interpretation. In fact, I was going to come back to fairness in due course.
And you're coming on to retrospectivity anyway,
yes.
but just picking up my Lord's point.
Yes, I don't balk from that from that submission. We say that that was the intention, and it shouldn't create unfairness between individual leaseholders, for that matter, those who have contributed in the past and those who are yet to be built.
Even though that does seem to be contrary to what we were shown of what was said on the floor of the House, which is that as far as retrospection is concerned, people who've paid shouldn't get their money back. That wasn't the policy intention.
Well, the way that that section 124 has been applied in my submission achieves exactly that.
Thank you.
Whatever was said on the floor of the House. In terms of retrospectivity principles, I hesitate to go into too much detail. I really only need to refer to two authorities. The first of those is the AXA case in Hippersley, in the Hippersley authorities. So that's at page 1205.
Do you know the tab number?
It's tab 38.
Thanks.
And I simply refer to Lord Reed's judgment at paragraphs 120, so it's the bottom of page 1205. I just invite you to refresh your mind on that. It's repeated in textbooks and so on.
So 120.
And 121.
Yep, we'll do that. Yes. In terms of principles, it's always difficult to find any hard rules. Obviously, the courts spend a great deal of time telling us we shouldn't apply rigid principles, and counsel spend their time trying to identify them. One of the ways that it's been put was by Lord Mustill in the Sherifian case, which is in the Hippersley authorities at tab 19. That's page 372. So for me, that's an earlier bundle. Where Lord Mustill described it as essentially a question of fairness, and set out some factors which might well be relevant. At page 372, F to H. So you'd like us to read that?
Yes, if you could.
Yes.
Yes, and I've referred to to some examples of where those principles have been applied, in particularly in the Charalambous case, where the passage of Lord Reed was considered and applied to tenancy deposits, where the tenancy deposit scheme came in, and the issue as to the extent to which it applied to pre-existing tenancies where a deposit had been taken without complying with the new regime for tenancy deposits. The question was the consequence of that no notice to quit could be served, or no Section 21 notice could be served.
And just remind me, what's the logic that at the point at which the Act came into force, you then had to put the deposit into the regime, or how did it work?
Well, I can take you to it. I wasn't, apart from saying
yes,
it's an example of where it's been applied,
yes,
I wasn't going to rely on it other than to say those principles have been applied, because the legislation is so different
yes,
from what we're considering here. But since my friend invited me to refer to it, I have referred to it, just to explain how we say it fits in. It's just an example. But so what do we say applying those principles? Principles, inverted commas. The first thing is, we would say it was never a given that the appellant could necessarily have added its legal costs of Section 20ZA to the service charges when it came to making its decision to apply for a Section 20ZA order. Recovering those costs through the service charge was always going to be subject to all kinds of possible statutory restrictions. And you will, I've referred to some of those already, in terms of Section 19, Landlord and Tenant Act, the 18-month rule under Section 20B, forms of demands. All of these things could well have meant these were all hoops that had to be jumped through before there was any recovery. And of course, on top of that, there was the need to meet the terms of the lease. I'm going to ask you to turn, perhaps for the first and only time, to the lease itself in the additional bundle. If you turn to tab 3, page 58, you'll find, sorry, the additional bundle. Now I've got the wrong one here. Just bear with me. Which bundle is it? Yeah. All right. It doesn't unplug. Well, apologies for that. The page 58 is an extract from, in a sense, the relevant costs to be that are recoverable under the terms of the lease. And if one looks down that list, it's not entirely easy to see where legal costs of applying to
Paragraph 13.
Paragraph 13 would be the most likely one, but that would have to be argued. And certainly when it comes to those kind of sweeper clauses, they tend to be interpreted fairly restrictively. There's quite a body of case law now on recovery of legal costs through sweeper clauses. It will certainly, in this case, if it's sought to be recovered, be a significant difficulty that has to be overcome. But in any event, however one looks at it, it's a contingent right. It's contingent not only on overcoming the statutory fetters, but also on making a demand that follows the terms of the lease for a contribution to the service charges. It's therefore really in no different a situation to the existing legislation when it comes to service charges, in that they bite and have bitten for some time on pre-existing contractual rights. And we say that that is directly analogous. In addition to that, we have the language used by Parliament. We say that paragraph 9 is clear. And again, we have the explanatory notes, which I'm going to come to. Looking at the appellants' arguments, they what they say is that there's unfairness to landlords, but the Act appears to have taken the approach, as I spoke of yesterday, that in effect those with the deepest pockets pay, fairly or unfairly, and irrespective of many statutory and pre-existing contractual rights. For example, the disapplication of limitation periods. The whole structure of remediation contribution orders, which require people to pay even without any kind of fault on their part. That is, one can always characterise something as being fair or unfair, depending on which side one's looking at. But that seems to be the policy of the Act, that it is quite happy to disapply contractual rights where going back over a very long period of time.
Can I go back to something you said? You said the language of paragraph 9 is clear. And the relevant words are no service charge is payable. Does that mean no service charge is, after paragraph 9 comes into force, payable, 28th of June 2022? Or does it go back further than that? No service charge was payable.
Well, we say that there's no temporal limitation at all. It's simply that that provided a service charge related to the conditions in paragraph 9, that's it, and it does. It has no temporal limitation. It does go back retrospectively.
Well, this engages with the point I was asking you earlier about the effect of section 27A. So, no service charge is payable without temporal limitation. You say once this is in force, a service charge paid 10 years ago, for legal costs, for professional services relating to liability of any person as a result of a relevant defect, is now to be treated as not payable, and so you can go back and reopen the accounts from 10 years ago. That's as I understand your submission. That's what you mean by saying there's no temporal limitation.
Yes, there's no. We, as I say, we don't balk at that. We say that that that's the intention of Parliament, is not to disadvantage leaseholders who have paid or in the past, and to distinguish those between those that have paid in the past and those who are still to pay.
I mean, I quite absolutely follow the logic of that position. If you take it to the extreme, like the fire door was fitted in 2007, it's a bit hard to see why Parliament should have wanted leaseholders to be able to reopen that. I mean, why should they be able to?
It's in part because of it may well be in part because of the considerable difficulties that Parliament could see in attributing blame to any individual party, whether a developer, a landlord, or so on, that they simply intended to cut through all of that, and that went back without any time limitation.
If that had been the parliamentary intention, you're upsetting a system of payment, of liability to pay and payments, where people might quite reasonably have thought that those were all settled and passed. Mm-hmm. You undoubtedly could do it, because Parliament can do what it likes, but wouldn't you expect, if it was going to do that, to say no service charge is payable, and this provision is deemed to have always been in place, so that things which were at the time payable are now to be treated as if they weren't payable. That's the effect of what you're...
But that's already what happens with service charge litigation.
But normally with service charge litigation, you asked a question, well, I paid this 5 years ago, but was it actually payable at the time? And if it's not reasonably incurred, or the work wasn't done to a reasonable standard, or the right hoops weren't gone through, you can establish that it wasn't actually payable at the time, so you can get it back. This would have a different effect. It was payable at the time on this theory, but Parliament is now saying, even though it was payable at the time, we're now enabling leaseholders to say that it's not any longer to be treated as payable, so we can have it back, even though it was payable at the time. That is as far as you go that far.
Well, we would go that far, and we say that is entirely consistent with, for example, going back and providing a statutory right for various persons to get a contribution from developers who may have built premises 40 years ago, 50 years ago.
Okay. Well,
one may not.
Okay, let me just put the question again, and then I'll wait to ask this question again. If that had really been what Parliament intended to do, would you not have expected it to say, as it does in section 135, I think, this provision is to be treated as always having been in place? To make it clear, you're reopening past liabilities and treating things that were payable at the time as now to be treated as not having been paid.
In my submission, that's unnecessary because of the plugging in provision of paragraph 10. Because once one plugs into a regime which is capable of being applied retrospectively, this is capable of being applied retrospectively as well.
Okay.
Indeed, it might well have created inconsistencies and difficulties with the way that the approach to service charges is adopted.
I thought I detected in your skeleton, but I may be misremembering, a submission that was a much simpler one, which is that when Parliament says no service charge is payable, it means from today, from the 28th of June 2022, you don't have to pay any service charges. And that doesn't reopen anything you pay. There is am I wrong in thinking that? That is,
if I can explain that, that was my friend's intermediate interpretation, which he advanced below, and which was also rejected by the Upper Tribunal. Up until Thursday of last week, my firm instructions were that no service charges had been demanded as a contribution to the relevant costs of applying to the FTT, Section 20ZA. So I was quite comfortable, if I can put it that way, with the intermediate construction, even though, as a matter of principle, it could create all kinds of knock-on effects with the other provisions of Schedule 8. So my fallback position, if I can put it that way, was that intermediate position. But it's not one that I would advance for various reasons, not only because we were only told last Thursday, and the fact is that it had never been raised before, either in the FTT or the Upper Tribunal or in the chronology or in any of the witness statements or anything, that there was a contribution included until last Thursday. Not only that, but also that we say that it would create all kinds of difficulties for other provisions of Schedule 8, notably the paragraph 8 and cladding remediation, which, for reasons which I'll come to in a moment, may actually be the real reason behind this appeal.
so what were you told last Thursday? Because I don't think I've got a complete picture of the facts.
So I haven't got a fallback position that I adopt the intermediate position.
So Mr. Allison said yesterday some of it had effectively been billed, and that was what you understood for the first time last week.
Yes, and on that basis, we would, the intermediate construction would have been fine for us.
So it's still better than Mr. Allison's position, the main position, but not as good as he would wish it to be.
But I didn't quite. I checked my skeleton. I don't think I quite conceded the intermediate interpretation, but I can see why someone might take it that way.
Thank you.
Right. If I can just turn briefly to one or two matters raised in oral argument in the skeleton by the appellant. I've already made the point that we say that Section 124 has it provides a way of dealing with the difficulty of one set of lessees being better off than another set of lessees, depending on when the costs were incurred, and that may well be something that is touched on in the triathlon appeal, and so it may well be something that I'll need to come back to on Friday in the event that is explored. A sort of variation on that was in oral argument. There was a suggestion that a hypothetical situation was explored about a landlord who incurs a sum of money or includes in their interim service charge demands, which are issued before the Act came into force, and what happens at the end of the year. And in broad numbers, if I take as an example, a landlord anticipates it's going to spend about £50,000 in applying to the tribunal, and it includes a provision in the interim service charges for those before the Act comes into force. What happens at the end of the year? Well, what happens at the end of the year if the costs are actually turn out to be £100,000? Well, if the intermediate construction applies, does it mean that the totality of the £100,000 is engaged by Schedule 8, or does it mean £50,000 is engaged by the Act, by Schedule 8? Given that costs have actually only been incurred and added to the service charge bill at the end of the year, it probably means that nothing is payable at all, even though a £50,000 contribution has been made. In my submission, that's not a satisfactory way of dealing with it, and it indicates why the temporal limitation, which if a temporal limitation is placed on the word payable, it leads to difficulties which, taking away that temporal limitation, resolves. I've referred already to limitation, and so I take it on the chin that we say that it does mean that one can go back a very long time. But in my friend's skeleton argument at paragraph 53, and I can take you to that in the core bundle. There's a reference there to the other protections in Schedule 8 using the same language in the present tense. And it's then said that one can assume that all of the other protections operate in the same manner. And if the provisions simply required the FTT to consider what is presently payable, even if the relevant costs were incurred prior to the Act coming into force, then there would be no obvious or apparent limit to how far back one could look, because there is no limitation period applicable to applications under the Act. And it refers to paragraph 8 of Schedule 8, which are the classic cladding remediation costs. And these are the really big ticket items under Schedule 8 when it comes to remediation costs. Millions and millions and millions of pounds spent across the country in remediating cladding. In my submission, this perhaps explains the reason why you have so many counsel and so much interest in a case which is about the legal costs of applying to the first tier tribunal. Because if the respondent's case is, the appellant's case is right, and there is a bright line cut-off as of the date that the Act came into force, many millions of pounds worth of cladding remediation costs could be passed on to lessees before that date. And there are obviously other provisions of Schedule 8 which deal with other costs. But in a sense, it's may well, as I say, explain why we are here. What we would say is that in itself demonstrates the unfairness. The unfairness would be to the lessees who would be in that position. In my submission, that cannot have been the intention of Parliament, to draw a bright line between the potential liability of leaseholders to contribute to removal of cladding or other costs as of the date of the Act. And that's certainly inconsistent with the host of retrospective provisions in the Act, some of which I've referred to. And obviously you will be considering certain aspects of retrospectivity in triathlon. Again, I think we'll consider that further. I think that is probably as much as I want to say on the general retrospectivity arguments. I will now turn to the explanatory notes, which hopefully I can deal with fairly briefly. We are in a slightly odd position where you've been presented with two versions of Benyon in respect of the explanatory notes. So you have Benyon at in core authorities at tab 15. Page 416. And tab 13.
It's not that. There's nothing there. It's been added.
Oh, sorry, that's the one that's been added.
Tab 50.
Yes, yes. There's been I think you've been handed up the latest copy of Benyon.
It was added.
I think some pages were added to the end of this tab.
Oh, I'm sorry.
Yes. Before the hearing started.
According to the index, the difference is whether it includes the second supplement or not. They're both from the 8th edition, but the one at tab 15 includes the second supplement. Is that correct?
Yes, it's basically a couple of paragraphs have been added in substance. If one looks at page 416, the paragraph, the heading started which versions of the notes may be used was not in the earlier editions.
Yes, I see.
And you'll note that that is the bit that refers to later editions, specifically refers to later editions of the notes. And also that there's no actual authority quoted for those changes, those 3 additional paragraphs. The respondent goes back to the case law, and we start with Chief Constable of Cumbria versus Wright, which is in the Hippersley authorities at paragraph at tab 31.
Tab, sorry.
The Hippersley authorities.
Did you say 31?
Yes.
Thank you.
It's page 958. And I just invite you to read paragraph 17 on page 958. And this obviously goes a lot wider than just explanatory notes. It talks here about official statements by government departments that are administering the Act. In my submission, that is the bright line that seems to have been drawn or it is suggested can be taken from Benyon.
Just pausing there. As you say, it's a wide net, but Mr Justice Lloyd Jones is saying, well, it's just the same as an academic article.
But one is entitled to take into account that this is the situation here. These explanatory notes accompanied the King's Printer's edition. One looks at the cover page of the King's Printer's edition, they refer to the explanatory notes.
I thought we were told that the explanatory notes didn't come into existence for some months.
I think that's because the King's Printer's edition wasn't produced for a while.
Well, something must have the signature of the King on it to signify royal assent. That doesn't contain, or does it contain?
I have to say I've never seen the actual signed vellum or whatever it is that.
But presumably the Act itself, once it's in force, is published on the website. So that would have been in June. And we were told these explanatory notes, the ones you seek to rely on, did not exist in June.
Well, all I can say is if one goes to the website and one looks at the King's Printer's edition, it says that it's accompanied by explanatory notes.
Well, the statute itself doesn't say that, does it?
No, it's the King's Printer's.
You just find it on the web. It's a short point.
Yes, yeah.
Just to be clear, what I'm familiar with is the legislation website. Is that what we're referring to? Or is that
If you go to the legislation website,
that's where you find the statute and it refers to the explanatory notes.
If you go to the PDF, it gives you the King's Printer's edition.
Oh, I see.
And that has a note on the front cover saying that it is accompanied by explanatory notes. You then go to another tab which gives you the explanatory notes, which are the ones that you've seen.
As I understand it, that is now the position, but that was not the position when the Act first came into force on the 28th of June 2022, because we were told the explanatory notes did not appear on the website until I think it was sometime in August. So would you accept that as a matter of fact?
I'm not going to contradict that. I don't have instructions as to the precise date, but this isn't just as one found, for example, in the Public and Commercial Services Union case, where there was just guidance issued by a government department. This was these were explanatory notes that accompanied the King's Printer's edition, if I can put it that way. And there was a close temporal connection with the preparation of the bill and those who actually drafted the bill, the particular government department involved. And so it's not only relevant within the Chief Constable of Cumbria versus Wright position, as expressed by the court in that case, but it has some added authority in my submission because of that close temporal connection and the origins of those explanatory notes. What we say is that what do you put on the other side at the moment? Because there is no academic writing. There's nothing else out there to suggest any kind of interpretation of the legislation. And so to suggest it should have no weight at all in my submission is not consistent with authority. It's a question of how much weight you attach it. And given that it only really affects things if you're not satisfied that the wording of the legislation is otherwise clear, it is there perhaps a feather to place in the balance to tip the balance in favour of the interpretation.
Sorry, I'm not following this.
Explained.
I'm not following this argument. If we come to the conclusion that the legislation, what Parliament has said, is unclear as to retrospectivity, I'm struggling to see how an explanatory note produced by a government department after the enactment can change that, because the principle of retrospectivity is looking for clarity in the Act itself.
We don't suggest that it's definitive. We say that it's one of the considerations that one adds to that weight, that scale, as to deciding on the meaning of the Act. Now, I don't know the extent to which, I gather explanatory notes are going to be looked at in the triathlon appeal. I've not really looked at how that fits into the triathlon appeal. Certainly the explanatory notes in that case, it doesn't seem to be an issue that they're relevant. Whether they're the same explanatory notes, I've not looked at.
I haven't focused my mind on this, but they too presumably bear on the reworked Part 5 of the Act, which obviously came along later.
Yes. I simply flagged that up as possibly another area where the Hippersley parties may actually be wanting to address you following the triathlon appeal, depending on how
Yes.
that goes. And in short, we say that that they are of some assistance in that interpretive process. So unless there's anything else, I think I have now about another 8 minutes, but I don't intend to use it.
That's very helpful. And I don't detect any more questions, so thank you very much, Mr. Loveday. Mr. James.
My Lords, I'm going to focus principally on Article 1 of Protocol 1 and the convention issues. The first issue that arises in relation to A1P1 is this a deprivation or is this a control of use? Our submission is that it is not a deprivation under the distinctions drawn by the A1P1 case law. On the contrary, it is a paradigm example of a control of use case. My learned friend Mr. Birdling sought to direct all of his submissions in effect onto the tightness of his definition of what amounted to a possession, namely, as he put it, accrued or contingent rights. We'll submit, by reference to the case law I'm going to take you back to in a moment, that the correct approach under A1P1 is not to atomise in that way and then focus on the right or interest affected only and say, well, that's been taken away, because you can always do that. You could have done that in the tobacco litigation in relation to the intellectual property rights that were involved with plain packaging versus lovely chapeaued Marlborough packets. That was not the correct approach. The focus under A1P1 in determining deprivation against control of use is a broader one, in which you look at the nature of the scheme in question, you look at the impact on property in a broad sense, and you look at, in particular, at the remaining uses that the owner of that property continues to have. You can put the same point in a slightly different way, which is to say you focus on the bundle of rights that are comprised in the property which the legislative scheme controls. Ultimately, the test for deprivation under the case law is a high one. The question is whether all meaningful use, that's the phrase used in the case law, of the property.
And there, as you say, it depends on what you take to be the property. Because were you indeed to focus on an individual contractual right to sum of money, well, obviously all meaningful use is gone.
Right.
So the real point of contention between you and Mr Birdling must be which property you're focusing on.
Yeah, what's the nature of the focus? Is it on the broader bundle of rights, or in our case, the building, if you will, or do you simply, as I described it, atomise it down? As I say, the case law is inconsistent with the latter.
Well, even if you look at the service charge as a right, it hasn't been removed altogether. It's its application to a particular set of costs.
It has. I'll agree with that.
I mean, just to be absolutely clear that this is obvious, if you had legislation which simply said in relation to an individual contractual right to payment under a particular contract, we're taking that away, that would be a deprivation.
It might be of that right if you were looking at it simply as that.
Yes.
But we say the focus from the case law is broader, and the result would have been very different in the Strasbourg case law that you've already seen. Because one could say in all of those cases there was an accrued right under the contract to the payment of rent at a certain level, and what the legislation then subsequently did was to interfere with that by saying you can't charge that level, you have to charge a lower level.
With the distinction Mr Birdling says is, well, that's looking to the future. We're looking to the potential for future payments rather than an accrued payment.
But my lord, that's just an exercise in casuistry, because you can see from those cases that there was already a right to the payment of rent at a certain level. None of the reasoning of the court in Strasbourg in any of those cases drew the distinction between prospectivity and retrospectivity for this purpose. On the contrary, they simply looked at the broader package of rights that was comprised in the buildings and the rent that they were able to charge and whether or not they could continue to sell the building and so on. So none of the reasoning of the Strasbourg court is dependent upon the distinction that Melanie Friend has to espouse, because his whole A1P1 hangs on the pure distinction of principle between prospectivity and retrospectivity. That's not the way the case law approaches it. So Malacca first, if I may, tab 16. And the paragraphs of importance for present purposes are paragraphs 43 and 44. 43 and 44. Then if I took you to them yesterday, but can I just invite you to cast an eye down page 293, paragraphs 43 and 44. Can I just invite you to read them to yourselves again?
Yes.
Just to get the paragraphs in your sight lines as well.
Yes.
So you see the way in which the court has reasoned it. They acknowledge, as it were, that there, in the first sentence of 43, that there's a contractually agreed right to rent in advance of the legislation. That's the accrued right, if you will. The legislation comes in and it bangs the rent right down. And what is said is, well, the effect of that is in effect an expropriation because the rent's been reduced to such a level. And the reasoning of the court is in 44, and you can see the broader focus. In 44, second sentence, there was no transfer of the applicant's property, nor were they deprived of their right to use, let, or sell it. That's the building, therefore. The contested measure, which admittedly deprived them of part of their income from the property, so if you atomise it, that's the bit that's been taken away / deprived on Mr Birdling's analysis. The contested measures which admittedly deprive them of part of their income from the property amounted in the circumstances merely to a control of use. So they're acknowledging, as it were, that if you look at it in that very narrow way, you've got something which could be called a deprivation. That's not the right way of looking at it. Because in the bundle of rights that is comprised for the landlord under that property, they can do all the things that they referred to in the previous sentence. could still use it, could still let it, could still sell it. And it was that broader focus, therefore, that stopped it being a deprivation of use and meant that the rent control was part of a control of use scheme in the legislation. So that is Malacca. Rutland is to the same effect. That's in tab 30. I think that's probably in a separate bundle. And Rutland is at tab 30, page 8 through page 60, it starts. And the page I want is page 914. And the paragraph is 160 for present purposes. And here the point is that the interference with the overall bundle was extremely intrusive, it might be thought, but was still classified as a control of use. If you go back to the head note, for example, you can see the nature of the interference in question. Go back to page 860, keep a finger in paragraph 160, go back to page 860. This is a reversion, as it were, of the previous communist regime and the whole series of measures that flowed from that. You see in broad terms the nature of the intrusion or interference with rights. And then you can go back to 158 and you can see the applicant's submission on the back of that. Effectively said she's an owner only on paper after those restrictions have been introduced. So much more extreme than a narrow alteration of some of the rights. And then the reasoning of the court is pretty short, it's at 160.
Yep.
So she couldn't even get physical possession of the house. And her rights in respect of letting them, including the right to receive rent and to terminate leases, have been subject to a number of statutory limitations. She'd never lost, however, her right to sell the property, nor have the authorities applied any measures resulting in the transfer of her ownership. In the Chamber's opinion, degree of the state's interference, and not its nature. State control over the use of property.
You sometimes see that expression in the Strasbourg authorities, de facto expropriation, to perhaps indicate the nature of the extension that falls within deprivation, if it's not actual expropriation.
It isn't just formal legal expropriation.
It's tantamount
to.
Yes.
Exactly. And one sees that in very many of the cases.
It was seen initially or early on in Sporrum, for example,
Yeah, exactly.
where you had the long-dated expropriation permits, but no actual expropriation.
Yeah.
It was like a blighting situation, combined with, just looking at it again, the control on the use of the property, what you could do with it in the meantime.
Yeah. Well, you're right. I mean, but that's the way it's done. It's, again, all illustrative of that broader focus and then applying a pretty high test. But we get the same basic ideas from Lindheim, tab 45 this time, if you would, starting at 1511, so tab 45.
Sorry, tab?
Tab 45. Just cast an eye, if you would, over the head note, H1 on page 1511, with the context.
Yep.
And then 77. The court shares the applicant's view that the low level of annual rents, in their case, less than 0.25% of the plot's alleged market value, indefinite duration of the impugned rent limitation, interfered to a very significant degree with their enjoyment So even, it's pretty extreme. However, for the reasons said above, the court is not persuaded by the argument that the application of section 33 to then amounted to expropriation or de facto appropriation, or that it meant all meaningful use had been taken away. And all meaningful use is the test, and you see the footnote.
Yes.
It's
Fredding.
Fredding, yeah.
Another well-known case.
Exactly. And if you want that in the raw, it's in tab 17, 17, don't invite you to go to it now, but it's tab 17, page 310, and it's at paragraph 45 of the all meaningful use test. You see the all meaningful use test being put together there. I wanted to go to one English authority at the level of the Court of Appeal. This is the one I was referred you to about the plain packaging in tobacco. That's the tobacco case of tab 50, 50. Lord Justices Lewis and Beats and Stephen and Richards. See in particular the analysis. I'm not going to invite you to read it all, but you'll note the paragraphs that are in particular of some interest essentially are paragraphs 91 through to 100. They start on page 1704, so we're tab 50, page 1704, you see the passage beginning A1P1 above paragraph 91. And you see the distinction that they then drive at. And in effect, the argument that was being mounted by the tobacco companies there was exactly the same as the argument that Mr. Birdling is running here. You take it down to a certain level, you identify the thing in question, the bit that is actually affected in a way that is supposed to be extinguished in that case, the property rights or the intellectual property rights that were associated with putting red Marlborough Chappell on the cigarette packets rather than sludge green on the packaging.
So can we understand how close the analogy goes? I haven't looked at this case really, I'm afraid. So British American Tobacco were saying they had intellectual property rights to use certain trademarks,
Yes.
whatever. And they were saying the legislation constrains them in the use of their trademarks.
So that for the purpose of putting their marks on the cigarette packaging, the legislation said you can't do that, it has to be sludge green or whatever it was.
I mean, it's still, as Mr. Birdling would say, not an exact analogy. That is constraining use for the future, whereas, as Mr. Birdling would say, this is an absolute deprivation of the particular contractual right.
My lord, yes, and my submission is going to be that that isn't the way that the case law operates.
Yes.
It doesn't hang it all on prospective, retrospective. I'll come to that when I come to the application of these principles in 1 second. But
Yes.
That's the submission.
But when you look to the future in the present case, what the statute imposes is an inability to recover the service charge.
Oh yes, but I don't want
So whether
Yes.
it's looking back or looking forward, the degree of the interference is similar in nature.
Yes, and as I say, I mean, part of the answer to it not being determined by prospectivity or retrospectivity is because, as my Lord's question indicates, retrospectivity, and as Lord Mustell pointed out, retrospectivity may very well be a question of degree.
I asked my question from the point of view of looking at deprivation in terms of how much of the property rights are removed. It's the ability to recover a sum of money
And only a narrow sum
in
of money.
respect to particular costs.
Exactly, leaving all of the other rights intact, as it were, and in relation to this one historical defect. But you'll see, just to go back to 1704...
I mean, the difference is, looking at prospectively, you might not incur the costs in the first place, but that, as my Lord observed yesterday, is subject to your obligations.
Your contractual obligations anyway. Exactly. So it all goes back to the package, as it were. But you'll see the nature of the analysis. I don't go through it in any great detail. You've got a reference to a bunch of Strasbourg and EU law cases. You see the critical distinction which they identify at paragraph 93 in particular the removal or cancellation of licences. See paragraph 96, any meaningful use again.
And then, as you say, it depends where you focus.
And that's really the point being made at the end of 96. The rights may lose some of their substance, but provided they don't disappear, it's unlikely interference will be a de facto expropriation. But even when you have lost the legal title, it's gone that far, and they give the J.A. Pye example in paragraph 97, and also the Agossic case, halfway down paragraph 97, which was the golden coins being taken away. They were, as it were, confiscated by HMRC at the border, because they were being smuggled in, and they were taken away entirely, and even in that circumstance, where you were just simply dealing with gold coins that were then confiscated, that was still a control of use. And then they consider a whole series of cases in which the control of use conclusion was reached, despite the effect of what was being done being to remove or cancel licenses or banning the sale of particular goods that were vital to the continuing viability of the businesses. And so, for example, Pinnacle Meat and cattle deboners, as it were, that's the first example in 98, forced out of business, lost its goodwill, Commission nonetheless treated the interference as the control of use on the basis that it was still open to the complainant to use its tangible assets in an alternative business that could have repurposed the factory. And then Ian Edgar, a similar thing, this was the ban on the handguns from following Dunblane. And Eastside Cheese, you'll all be very familiar with the Lord Bingham. And it was our judgment in that. And then the broader submission that I made in that case, which the Court of Appeal accepted, look at 100. Accepting the submission on behalf of the Secretary of State that whether the alleged interference is part of a general scheme of regulation is of significance in deciding whether it amounts to a control of use. And then they come to apply that. So you've got the same themes in there. You don't just look down to see whether a particular part of the claimant's possessions analysed narrowly has been in effect taken away. That was the position in tobacco. That's why they were trying to rely on all these cases. It was the position in Ian Edgar in relation to the handguns. It was the position in Pinnacle Meat. It was the position in Eastside Cheese. And all of them were characterised as control of use cases because they've still got some meaningful use that can be made of the property in a broad sense. And moreover, even if you've got something which looks totally like a deprivation, a gossip is perhaps the paradigm example where the gold coins are confiscated at the border, if it's part of a broader scheme of control there of import-export of gold, that will be, and indeed Eastside Cheese is an example of the same thing. The fact that there's a general scheme of control that is introduced is itself relevant, even if something looks very like a deprivation in normal parlance.
And Veconi, which is at 99,
Yes.
where there was a licence that was cancelled, the court says the licence is a possession.
Yes.
So you've lost that possession.
You have.
It still ends up being control of use.
Yes. And that's because possession is defined relatively broadly to include a legitimate expectation of the continuation of the ability to do something. The paradigmatic case of that being a licence example. But my lord is right. You focus on that. You call the licence properly under A1B1 analysis for that reason a possession. It's the thing that's been taken away. The focus is broader. It's part of a scheme of control. So to come to the application of those principles, as I say, you know, my learned friend focuses on accrued contingent rights being the possessions, and he says, well, viewed in isolation, they're taken away. He adds in, they're taken away retrospectively. Those were rights under leases entered into before the legislation in question that limits the rights. So if you view it narrowly, he says, well, they've been taken away or deprived, or something very close to it. And my answer to that is threefold. One of them, the first answer, is that of all of the cases in Strasbourg that we've looked at involved rights in question, sometimes under leases, sometimes under licenses, sometimes gold coins. They all involved rights or property which were later altered by a legislative scheme, certainly in the property cases. The position here is indistinguishable, therefore. Secondly, the general principles from the case law are evident anyway. It isn't right, under that Strasbourg case law, in principle it isn't right, to look at it in the narrow way that my learned friend seeks to do. What you look at is the bundle of rights, or in the property cases, what's left of your rights in relation to the building, to the lease, if you will, if you're the landlord. And it might be thought, perhaps I left Frederick a bit quickly, I'm not going to go back to it, but you'll see when you get to go back to 45 of Frederick, the one at tab 17, that the court in Strasbourg makes expressly clear there was an effect on a gravel pit that was owned by the applicant. And they made clear that that shouldn't be looked at in isolation, their words. Instead, in order to take into account, they say, the realities of the situation, the effects of the revocation have to be ascertained also in the light of the situation obtaining on the applicant's surrounding properties. Same point. And what that leads to, and this is the third submission, is that the distinction in the Strasbourg case law in principle between deprivation and control of use is a distinction based on the quality of the interference, if I can put it that way. And you can't term mere prospective or retrospective effects as being determinative. What, for example, if you have 1 day of retrospection? It's simply a factor principally relevant to the question of proportionality in the analysis when you get there. It isn't a determinant of the character of what is being done as either a deprivation or a control of use, for the reasons that I've given. And I should add, just before leaving the topic, that the distinction is principally thought to be relevant, or in the past was principally thought to be relevant, because it has impacts into whether or not the state needs to provide a scheme for compensation. As we know from the Supreme Court's decision in Mott, that my learned friend took you to tab 52, the distinction between deprivation and control of use, even for the purpose of compensation, is not a sharp one, it's a spectrum. It's an analysis on spectrum rather than a sharp line.
I mean, in a true deprivation case, there is very little, isn't there, European Court of Human Rights Authority sanctioning a lack of compensation.
Very little. If it is characterised as a
deprivation.
And no doubt that's in part driven quite a significant chunk of the case law that says it isn't a deprivation.
Yes.
If that consequence automatically follows, but the later case law, of which Mott is perhaps the paradigm example, slightly greys that.
Yes.
And that's why in Mott they said what really matters is the severity of the consequence for the individual. And it may be that in certain circumstances, even if you're not technically a deprivation, compensation might be a necessary ingredient in proportionality or in fair balance. So I don't put it as hard edge, but I do accept my Lord's general proposition, which is that's Strasbourg case law looks at it in that way.
Yeah.
So that's what we say about that.
And you were submitting a moment ago that the distinction between prospective and retrospective is dealt with in the proportionality part of the analysis as we get there. But even when you look at the compensation cases, Strasbourg does not insist upon full market value.
It doesn't.
If that's meant to be a proxy for getting back the entirety of what you were able to enjoy previously. I mean, see, for example, James, the leasehold enfranchisement.
And Lithgow.
And Lithgow, the ship, that was
The shipbuilders.
nationalisation of shipbuilders.
Exactly. Oh, yes, you'll be very familiar with those cases, I know. But yes. So that's what we say about that distinction. I don't need to deal with any more of that, I think. I wanted to turn to justification. And I wanted to start with the basic approach, and then I'll come to some of the key factors that apply from that basic approach here. The absolutely fundamental approach is the four-stage test from Bank Mellon. Very, very well known, probably too well known to require further citation. But my learned friend took you to Lord Mance in the medical costs case and said, well, there you go, that's the approach. And some of the paragraphs he took you to, trying to make this a bit simple, some of the paragraphs he took you to appeared to suggest that when you were applying the manifestly without reasonable foundation test, or margin, and manifestly without reasonable foundation is just simply a shorthand for very broad margin, as we know from Lord Reed and SC, which I'll come to. But when you're applying that test, there may be a distinction to be drawn, proffered Lord Mance in the paragraphs my other friend took you to from medical costs, between the first, second and third stages of the Bank Mellon justification analysis and the fourth, which is fair balance. And that impression, if my learned friend was leaving that impression with you, is not an accurate one. I'm going to take you to one authority. There was, if I can put it this way, an almighty ding-dong in the Supreme Court following that judgment about whether or not that was in fact the correct approach in principle. And it came back and back to the Supreme Court in a whole series of social security cases, MA and then a case called DA in particular. And to cut a long story short, I'll take you to the passages in the one that finally gave it the quietus. But to cut a long story short, the Supreme Court retreated from that position, acknowledged in terms that the right approach was to apply margin across all stages of the justification analysis, in effect, including the fourth stage. And they've proceeded that way ever since, including in SC, which you will see in a moment. But can I just take you for that purpose to I hope you've had a smallish bundle. I'm afraid it yet burdens you with more material, but there are only four authorities, and I want the first one, first tab, which is DA in the Supreme Court. It had reached a pitch where they put 7 of the justices on this court, and Baroness Hale and Lord Kerr dissented for different reasons, but disagreed with the rest of the collegiates. And I wanted to start, if I may, with Lord Wilson. Page 20 of this bundle, page 3307 in the Weekly Law Report, you will see a title just above the first hole punch, issue 6, Focus of Justification. I've always got that. And then below the second hole punch, Test of Justification. And you will see, if you go over the page, that he cites from Lord Reed in G. See in particular paragraph 93 within that quotation between the two hole punches on page 21, said Lord Reed, that consideration is relevant to these appeals if the question of proportionality involves controversial issues of social and economic policy, major implications of public expenditure, the determination of those issues preeminently a function of the democratically elected institutions, therefore necessary to give due weight and so on. And then, as Lord Wilson noted, Lord Reed then completed para 93 by adding, unless manifestly without reasonable foundation, their assessment should be respected. And then he goes back to the Strasbourg case law, which we'll be very familiar with, James and Steck, for manifestly without reasonable foundation, it being firmly rooted. And then you will see the beginnings of a recantation, as it were. Paragraph 59, bottom of page 21, I now accept the weight of authority in our court mandates inquiry into justification of the adverse effects of rules for entitlement consequences by reference to whether they're manifestly without reasonable foundation. And then you'll see he refers specifically to Lord Mance and the recovery of medical cost case in paragraph 61. And you'll note that by the letter D on that page, within paragraph 61, he notes paragraph 52, which is one of the paragraphs my learned friend took you to yesterday. This is about the splitting out of the approach between test 1, 2 and 3 and test 4. That's the passage he's considering. And then he traces the case law that's happened since then. The Wales case at 62, 63 he deals with the bedroom tax case, where there was a very prolonged debate about this very issue and whether Lord Mance got it right or wrong, and Lord Toulson, for the entirety of the unanimous Supreme Court in that case, you'll see summarised in para 63. Go over the page to page 23 in the electronic, if you would, or in the hard copy numbering. In paras 29 to 38, this is in Lord Toulson's judgment, he then set out at length set out the reason for this conclusion, in which all the other members of the court concurred that the Court of Appeal had not erred when, in assessing justification for the effect of the rules on the claimants, it had asked itself that single question. So it's a single question approach, manifestly without reasonable foundation. That's the correct approach, said the Supreme Court in MA, post Lord Mance's judgment, para 52, splitting it out. 64, the recantation becomes clear between C and D. It was in the course of my judgment in para 33 that I cited Lord Mance and so on. Drawing that distinction, adopting the distinction that Lord Mance had adopted. And then in paragraph 65, between the letters, directly between the letters E and F, I reached too quickly for the observations of Lord Mance in the Wales case. Clear authority, Humphreys, bedroom tax, and so on. Sole question is whether it's manifestly without reasonable foundation. Let there be no future doubt about it. So that's Lord Wilson, and then if you go forward in the judgment into the judgment of Lord Carnworth, and in effect the other non-dissenting members agreed with Lord Carnworth, Lord Hodge, Lord Hughes, Lord Reed, I think. But I picked this up under Test for Justification, page 34, paragraph 110. Endorsing Lord Wilson's statement, there should be no future doubt, so it's pretty evident what they're doing. They're trying to put the thing to bed once and for all. See paragraph 110. He says, not accepted by all members of the court, the two dissentients for present purposes, the Lady Hale and Lord Kerr. Then he goes back to the analysis and does the analysis himself. 112 over on page 35. The MW, that's manifestly without reasonable foundation, the acronym. He cites Humphreys. and you'll see the nature of the argument. It's specifically being argued that Lord Mance was right in recovery of medical costs to split out. You see that from 112. This is Mr. Wise for the claimant in that case, effectively arguing that there is a distinction. And then 113 says, with respect to members of the court who think otherwise, clear in my view that the MWRF test remains the appropriate test in the present context. 114, citing Humphreys, that passage shows authority at the highest level in this country for the application of the MWRF test. It goes back to various cases which he then cites. And then at 116 on page 37, can I just invite you to cast an eye down that? It goes back to the bedroom tax case, the MA case, unanimous Supreme Court. That's why you apply MWRF at all the stages.
Yes.
Yes? So, and then he analyses Lady Hale's judgment and Lord Care's judgment at 117 to 118. But it's all to the same effect. And you see Lord Hodge and Lord Hughes agreeing at 125, for example. So, the short point we make is that the breadth of margin that is appropriate to be accorded, and if it's MWRF, it's MWRF, applies at all stages of the proportionality analysis, the justification analysis, from legitimate aim through to fair balance. And to the extent that Lord Mance might be taken to have suggested otherwise in medical costs, the Supreme Court have concluded that he was wrong to do so and have reasserted the orthodoxy.
Is there some suggestion in DA that is where what one is dealing with is a welfare decision where you have policy decisions on economic and social matters, and that there are other types of decision where what Lord Mance says might still apply?
My Lord, the answer to that is no, I think. We had that debate in a case that went to the Court of Appeal on social housing and discrimination, called JCWI, which is the second of the authorities in this bundle. And the conclusion, perhaps unsurprisingly, given the logic and principled approach to it, is that it would be very odd indeed if it was restricted simply to social security, because the underpinning for the breadth of the margin that is reflected in MWRF is the same in other policy areas of a social and economic kind, of which JCWI was one. So JCWI wasn't about social security, it was about a different thing, housing and so on. It was still a discrimination case, but it doesn't matter for present purposes. And there they concluded, or they would have concluded, that it isn't just restricted to welfare. And we would add, for good measure, it plainly can't, in sensible, principled terms, be restricted to discrimination, because the battle that then developed in the context of discrimination, which one sees reflected in the SC judgment to which I'll come, where the Supreme Court again revisited all of these issues, the battle there was, what do you do when one part of your mind is saying this is social and economic, and the other part of your mind is saying, but it's discrimination on a suspect ground? That's the balance and the dilemma that they're struggling with in SC. How do you approach that? And on that basis, for example, a straightforward argument about A1, P1 with no discrimination element and the prejudice that might bring into the debate is a fortiori. You cannot have a stricter test where what you're doing is conducting a general societal balance versus private interest thing, where you haven't got the protected characteristics that underpin the Article 14 debate, if that makes sense. But can I just show you the bit now? There, I'll show you the bit in JCWI, because I anticipated that was going to be a question. But I hope it's been put to bed mainly, at least, by JCWI, and indeed the logic of the positions I've described, the principle underpinning for the breadth of margin, and therefore manifested without reasonable foundation. So tab 3, I'm sorry, and the tab 3 of the supplemental bundle. Page 110 it starts, that's JCWI. Can I just invite you to cast an eye down the head note just to give you the flavour, and then I'll take you to the key passage or passages. And really, the paragraph I want for present purposes is probably, I can keep it narrow, it's probably 133 on page 153. Can I invite you to read that paragraph to yourselves? It starts, however.
Yeah.
But just have a look at 133, and in particular, I've done double sideline, if I'm allowed to mention it at least. I've double sidelined Roman 3 and Roman 4 in particular.
We'll do that.
Thank you. Roman 4, which was the logical point I was putting in my Lord Justice Nugee in answer to the question you raised. It must apply where the principled underpinnings apply, is the short point.
But obviously that's expressed in terms of sensitive areas. You would say that this is a sensitive area too.
My Lord, yes, I think by sensitive areas, it means sensitive in the sense that they give rise to issues of policy that the democratically responsible bodies are better placed to make, i.e. the previous sentence.
Yeah.
It's not referring to sensitivity in the usual sense, I think, if I read that correctly.
Well, the previous sentence is talking about unique qualification to assess the public interests as against, in other words, competing interests.
Yes. Yeah. Well, that's JCWI. Can I go briefly to what is the current leading authority on...
And here you've got a clash between different property rights, potentially.
You have, and
So, see, for example, section 124.
You have. I'm going to come to apply that in due course. I just wanted to get the approach and principle absolutely locked into my Lord's heads, if I may. SC, which is, again, another discrimination case. It's A for sure, I for all the reasons I've given. SC in the Supreme Court, again, a very large court. They took the opportunity of clarifying a whole series of issues of principle. In this case, that's at tab 61. So probably in your final authorities bundle. Again, it's a 7-person court, as you see from page 2109 behind tab 61. You see the context. This is the 2-child tax credit rule. And it involved discrimination issues of a sensitive kind and so on. So, but you see that this time we've got a totally unanimous Supreme Court. Look at page 2126, with Lord Reed as the President giving the judgment of the court. And I go to this for the approach to margin. As I say, most of this is concerned with the battle between the question, what do you do when one strand is pulling socio-economically towards broader margin, and the other hand is pulling in the opposite direction because you may or may not be leaving suspect ground. And the answer in a nutshell is that the socio-economic side tends to win out, if I can summarise it in a sentence. But just so you see the principles that the Supreme Court alighted on, the key paragraphs, just by way of summary, are in 115, paragraph 115 on page 2157. see the court makes clear in this judgment that manifestly without reasonable foundation is just a shorthand for a breadth of margin which is dependent upon a range of factors, particularly in the discrimination context where you're dealing with a pool of potentially suspect grounds on the other side, which obviously doesn't concern us. Then 157 to 162 on page 2170. In particular 161, you see the range of matters referred to in 161, substantial weight in fields such as economic and social policy, national security, penal policy, and matters raising sensitive moral or ethical issues. And then they refer to JCWI, which you saw. Ordinary approach will accord the same margin for the decision maker as the manifesto without reasonable foundation. Formulation and circumstances, particularly wide margin, is appropriate.
And the current case fits into the bucket of economic and social policy? Or?
Yes, it does. Plainly, in my submission. And paradigmatically so, I thought. So, just pause there for a moment. I'm going to come to the end of the judgment because we'll see how the court went about applying these principles. But in essence, you get a very wide margin as reflected in the phrase manifested without reasonable foundation as the shorthand. You get a very wide margin based, first of all, upon the Strasbourg authorities, cases like James and Lithgow, and all of those cases which acknowledge that in terms and use that phrase. That's where it started. Manifested without reasonable foundation was first used in James. But you also get it, that breadth of margin, although it's called something different because it's a domestic idea, dependent upon the constitutional actor. So under our system, Parliament sits at the top of that tree, Parliament in primary legislation. And again, Lord Reid has made clear over the years that you accord particular respect to judgments that are made by Parliament. And normally the debate in that respect focuses on whether or not you're dealing with a particular species of legislation or another particular species of legislation. So you get top respect, if I can put it that way, if it's primary. You might get a bit more, you might get a slightly lesser respect if it's affirmative resolution process, and a little bit less again if it's negative resolution, but you're still getting some respect because it's legislation. And then you come down to the executive. The principled underpinnings are very well established now. Cases like Begum and all of those cases, which are who is the constitutional expert, who is more appropriate to make these decisions, and which is the democratically accountable institution. So you see in SC the working through of all of this towards the end of the judgment, and you can see, in particular, if I can take you here, para 207. Invite you to read that. Again, it's very fact specific here what Parliament was doing when it was doing the two-child rule.
Shall we just read the paragraph?
Yeah, 207 if you will. Can you read 207 and particularly 208?
Yes.
Because 208 is the principle that flows from their factual analysis.
We'll do that.
Thank you.
Yes.
So you see the significance of 208. I'm going to stop drawing parallels in a moment, but you see the significance of that statement of principle. And that idea about there being no legal standards by reference to which you can make as a court those sorts of fairness judgments, that was reflected, it's essentially a similar point, but it was reflected in the judgment of the Court of Appeal in this case. That's the SC case, and that's the authority you have at tab 2 of your supplementary authorities by law. I can just invite you to go there so you can sideline 2 passages from the judgment of Lord Justice Leggett, recognising that when you've been elevated you acquire mythical status. But this was what led to and appears to have been the germ of the idea that is reflected very crisply by Lord Reed in 208. Can I invite you to go for this purpose, page 88, tab 2 of the supplementals, page 88, paragraph 87.
So should we read that?
Can you do that? Just quickly, you'll see the similar themes being laid out. And again, that idea about no legal standards all ties into the breadth of the margin, manifested without reasonable foundation, and so on.
Yes.
That then leads, in the conclusion of the Court of Appeal, to 158, paragraph 158 on page 108. Again, can I just invite you to cast an eye down that, and you'll see the source, as it were, of the Lord Reed analysis effectively agreeing with that approach. I wanted to identify against that. I'm sorry it's taken a little while to go through the case law, but at least you've then seen how the Supreme Court are now approaching these issues. I wanted to identify on the back of that case law 5 particular features and factors that apply here. Firstly, we are dealing with, in this legislative scheme, social and economic measures of a classic kind. We've got a one-off set of measures designed to deal with serious historical safety issues in a way that fairly distributes the very large financial burden of rectification, in a nutshell. That's the nature of
The statute itself doesn't involve choices about the expenditure of public money. It's dealing with the distribution of costs between...
It is, but as I'll show you from the evidence, the distribution question did involve taxpayer funding as well.
Well, I was going to say...
Because the government was pitched in...
Well, that's going to be my question.
Yes.
Was the BSF context in play when the legislation was going through?
I think so, and you see from the witness statement of Mr Murphy, which I'm going to travel through swiftly in a short while, that in effect the judgments that were involved were who should bear the burden of the cost of rectification. And the starting point, as it were, was that the government, brackets the taxpayer, had already were going to pick up a chunk.
The absence of that headed funding
shaped how much you then had to find.
But the absence of that in the statute is not significant.
No, it isn't, I respectfully submit. But you're dealing with that essential issue. It's driven by safety, but it requires societal and economic solutions in judging how to share that burden. Everyone agrees that you couldn't end up, particularly post the tragedy in Grenfell, you couldn't end up with a situation in which the buildings were not being put right because they represented a current hazard to life. The question was how that should be paid for. That's what the Act is really driving at. And as you've seen from both Lord Justice Hickenbottom in JCWI and then Lord Reid taking it forward, particularly in 161 of SC, it applies across the legislative board. It isn't just a social security thing, because the principal underpinnings apply more broadly than that, and it isn't a discrimination thing, because A1P1 balancing is a fortiori, because you don't have the protected characteristics in play. So social and economic measures of a classic kind. Secondly, no one has suggested that there is, and Lord Reid, as you'll recall in 115, placed some emphasis on this, no one suggested there's some form of consensus in the Council of Europe as to how these sorts of issues should be dealt with. And that's perhaps entirely unsurprising, because you're dealing with a one-off historic problem. So you don't have the driver that sometimes shrinks the margin and requires a different outcome that you have, for example, when issues to do with sexuality have moved in a particular direction consistently across Council of Europe states. That can shrink the margin and drive a more intrusive outcome. No, we're not in that territory at all. That's the second point. Third point comes back to the domestic constitutional point I made. These are balances. This distribution is struck by Parliament in primary legislation. And that reason alone renders it constitutionally appropriate for the highest respect to be accorded, because of the nature of the constitutional decision maker. And these are all matters of judgment. It might be thought that they are obviously matters of legislative judgment. Where do you draw the lines? How do you draw the lines in that distribution exercise? And they represent a deliberate choice or set of choices by Parliament. And you'll have appreciated already that the premise for the A1P1 debate is that the legislation means what we and the respondents say it means. So it's retrospective, and it divides the burden in the way that it does, that flows from that.
You say it means exactly what Mr Loveday says it means, so that you could reopen settled accounts from 25 years ago.
Well, I'm going to come with some temerity at the end of the submissions and very, very briefly to interpretation.
On that particular point, it may be of assistance in this appeal to understand how the Secretary of State puts the relationship between the leaseholder protections and, for example, Section 124.
Yeah.
I mean, for example, one question going through my mind is if, when Section 124 gets going, we have more cases in the FTT, if they find themselves forming just and equitable judgments about the distribution of costs of this nature, cladding costs, between different parties, is that undermined if
if you've got an absolute right underlying.
You can just, one party amongst that group of parties can simply rely upon a contractual right of recovery without constraint.
Well, my lord, I've noted it. Can I come to that when I deal with interpretation? The fourth point on the factors here for present purposes on justification are that the judgments are of a paradigmatically legislative kind in a context such as this. That's why I took you to Lord Reid in SC at 208 to 209 and Lord Justice Leggett to similar effect in 87 and 158 in the Court of Appeal. The fifth point to note is that these are necessarily, perhaps, or this is a bright line exercise. And it might be thought it is almost inevitably such.
Well, this aspect is, Schedule 8 is full of bright lines.
Yeah.
But this case we're hearing in the rest of the week, Section 124, actually transfers the decision making to the first tier tribunal.
Yes, my lord, what I mean by a bright line exercise is that in deciding which issues should benefit from the just and equitable thing that my lord has identified, that's a decision that Parliament has made. It's narrowed that bit and put that in there. It's drawn other bright lines elsewhere, necessarily, for example, in Schedule 8. And the balance of that distribution of decision making in relation to this context is itself an exercise in legislative line drawing. I also wanted to emphasise one final point on the principled approach, which we picked up in our skeleton at paragraph 46, and I invite you to go back to it now, but it's that point about the less intrusive measures part of the analysis under justification. That also involves an exercise of judgment. It isn't an objective question for the court to decide whether there is some lesser means which could have been used. The question, as was made clear in the passage from Sir Terence Efferson's judgment, I think it was, in the Court of Appeal in the Cultural Antiques case behind tab 56. I don't invite you to turn it up for this purpose. We've quoted the relevant bit in our skeleton at paragraph 46. What that illustrates is that the less intrusive options question within the justification analysis is one that asks whether there were less intrusive measures that would, with equal effectiveness, have achieved that would as effectively have met the legitimate aim. And the moment you add that last bit in, you see it's an exercise of judgment, and so that's why margin applies there as well.
You can always postulate some slightly less intrusive measure, which would achieve much the same thing.
That is definitely not the test. Does it do so as effectively? Does it pursue the legitimate aim, sort the legitimate aim, as effectively? And the moment you introduce that, as I say, the question by definition raises questions of judgment. How far do you want to go? How hard are you pursuing that? In what ways are you pursuing that? But that all feeds back into this idea that the idea of the breadth of margin, for all the reasons I've given, applies at all stages of the analysis, as the Supreme Court has now made absolutely clear. I wanted to give you two references without inviting you to turn them up because they are very much by way of footnote, but into the Strasbourg case law, applying manifestly without reasonable foundation, including in an A1P1 context. James, you'll be very familiar with. That is in, Lord Justice Holgate, well, because you cited it in the Annington judgment, but James is the Strasbourg authority in which MWRF was first coined, as it were, as reflective of that broad margin. James, for relevant purposes, is behind tab 15, and the relevant paragraphs are 46 on page 253 and 68 on page 263. And you get the same idea exciting James, the later Grand Chamber Authority, which my learned friend referred to, which we went to principally for the purpose of the deprivation control of use issue. That's the Hutton case, tab 30, and the relevant paragraph in which James is cited for that purpose, i.e. MWRF, is paragraph 166. Well, there's a second footnote, if I may, which is about parliamentary consideration and the extent to which parliamentary consideration enhances or shrinks the margin. It's that issue. Can I just invite you to go back, sorry to go back, but to go back, if you would, to SC and Lord Reed behind tab 60 for this purpose. 61, so sorry. The paragraphs I want for this purpose are 183 and 184. Let's pick it up at 182 if you would. Can I invite you to read 182 through to the end of 184,
Yes.
just so you get the... So you'll see that what matters is that Parliament can be taken to have considered the issues. No part of the function of the judge to determine the quality of debate or the reasoning, is that for constitutional reasons amongst others.
In that context, it may also be relevant to look at page 2176 of the bundle, paragraph 1763, which is cross-referenced by Lord Lee.
1763.
1763.
Paragraph 176.
Yes, paragraph 176, subparagraph 3.
Yeah.
That's what he had in mind,
Yeah.
183.
Yes. Oh, you're right. And to some extent, these paragraphs might be thought to have flowed from what had been a building practice, as it were, which is for claimants to, as it were, trawl through the parliamentary debates and either say, well, you haven't got this specific thing being thought about by Parliament, and so you don't afford a margin, or if it has been thought about, the reasoning is no good, and so you don't have much margin. It's much more of a constitutional stand-back exercise. Can Parliament be taken to have made the judgments about the lines being drawn in the way that it is being suggested? What matters is that Parliament has actually considered the issues, and the issues may well be apparent if you're drawing lines from the face of the legislation which sets those lines. And so it may not be of any great interest to say, well, it was debated specifically or it wasn't. It'll often be self-evident, as I say, because the lines will be evident on the face of the legislation. On a slightly different but related issue, the Court, I know, has expressed some interest in the question, what about the statement of Mr Murphy, to which I'm going to come in some detail. And the answer to that is it's absolutely standard in a convention challenge for there to be, as it were, a corporate statement from the responsible department that has carriage of legislative proposals that then become legislation which is then challenged. I can't think of a single case in which there's been a challenge to the compatibility.
I think there was one recently in which you appear where the criticism was that there wasn't such a document.
Yeah.
A couple of weeks ago.
Yeah. Yeah.
Well, maybe standard. What significance is to be attached to it? I mean, it can't matter for interpretation. So,
my submission will be it can be relevant to interpretation. I'm going to take you to a judgment of Lord Justice Singh, which indicates that it may be relevant to understand, by way of a statement from the relevant government department, the object and purpose of the legislation in a witness statement, as long as it's recognised that what is not relevant to the issue of interpretation is an expression of subjective intention as to what the department thinks a set of wording means.
so that whether on that aspect or more generally, what are we going to get out of it that is not obvious in terms of the object of the legislation?
Well, my lord, you get the driver you get the drivers, you get the background, you get the context for the legislation, you get the mischief at which it was aimed, and particularly when you've got a complex scheme of legislation, where you in effect assume that Parliament understands all of the balances and all of the lines being drawn, you get that pulled together in an explanation as to why the proposer of the legislation that went to Parliament thought things were being done in a particular way, and that is relevant.
Well, I can't help feeling at the moment that we can sufficiently discern the object in something that could be written in a paragraph
Of this particular,
of anything. I mean, it's what the object of this legislation is obvious, isn't it? We don't really need Mr. Murphy to explain it.
my lord, you don't, but what you may need Mr. Murphy at least to seek to assist the court with is the way in which the background to it, the history of it, why things went the way they did, and how the various bits of the Act related to each other. Anyway, we'll have to see
what you
when we
say.
get to him. Yeah, we'll have to see when we get to him. But I respectfully suggest that this is not an unusual exercise, and it's. I know my lord says, well, so what? Unusual might be good or it might be bad. In principle, of course, I accept that. But it does go, as I say, to provide the detail of the object and purpose of the legislation and how the various bits hang together. Particularly when one stands back and one says, right, well, the basic driver of this, which you might say to me, well, that's perfectly obvious because that's what Parliament must have thought, was to provide a comprehensive scheme of leasehold protection. I thought it would be obvious from the nature of the scheme.
And in general terms, that's obviously right.
Yeah. And then the question is, how do you draw the line? And that's evident from the face of the legislation itself.
Or not, possibly in this case, hence the arguments about retrospectivity.
Yes, well, my lord, quite. But so there are limits, of course, I accept. Ultimately, the compatibility of the legislation is to be judged by reference to the scheme. And that is why you get a line of case law that goes the other way, it goes alongside this, that acknowledges that it may not matter for compatibility reasons, whether reasons have been the right reasons have been thought about by the executive. That line of authority that is misbehaving, and Lord Hoffman in misbehaving saying what matters is whether it's compatible, having regard to its effects. Wilson and First County Trust, same idea. So I accept that there are limits to it, but it's helpful nonetheless, I submit. Just as it would be helpful if you looked at pre-legislative materials like white papers and green papers, and consultation responses that precede the legislation. Those are very often referred to by the court to put some flesh on the bone of object and purpose.
Is it too simplistic to say we can't look at it to answer the question, is this legislation retrospective? We can look at it if we've decided that it is prima facie retrospective, whether it's compatible with the convention.
No, I don't think it's too simplistic to look at it that way. I think, as we all acknowledge, there is a broader church permissible in relation to the convention compatibility, but essentially it's doing a similar thing. So any part of what my lord put to me that I would potentially quibble with, for reasons which I'll show you Lord Justice Singh in that authority, is that object and purpose are critical to any exercise of interpretation.
Yes.
See the Supreme Court in Packer, Rossendale,
Yes.
all that line of authority. That's why Lord Justice Singh drew the distinction he did in the case I'll come to, on the pure interpretation issue, saying, well, sometimes it's jolly helpful to have a statement from the relevant government department, even on an issue of interpretation, as long as you recognise that them saying, we intended it to mean parliamentary draftsman in the past.
So we have to draw a distinction
I intended it to mean this, that doesn't take you anywhere.
We have to draw a distinction between what the object and mischief was,
as that feeds into the exercise of interpretation, compared to...
and what the solution was, the intended solution was.
Yes, or we intended the words to mean this. That's singling people out. So Stephen Laws was a great exponent of producing public documents saying, I intended the legislation to mean this, that must be right. That doesn't get you very far. But the objective analysis of object and purpose is more interesting. My Lord, I was going to turn to the application of those principles. Sorry, it's taken a bit of a while to get through them, but the application of those principles. Firstly, for all the reasons I've given, this is a control of use and not a deprivation. All meaningful use of the owned property has not been removed. You can recover other costs via the service charge. The charging preclusion only applies in relation to this particular set of issues in the way defined and limited by the statute. You can exercise other rights in relation to the building, including the right to receive rent, ground rent. The landlord can sell the building. You see the echoes into the Strasbourg case law we looked at. it is in any view, on any view, part of a broader scheme of control, back to the submission accepted by the Court of Appeal in the tobacco case, a broader scheme of control to ensure that major public safety issues were addressed and rectified, and that the burden of doing so was fairly shared in Parliament's view. So there is no question of compensation for deprivation even being an issue, even recognising, of course, that that isn't necessarily a binary question dependent upon deprivation versus control of use. There is a spectrum in the analysis, as one saw from the Mott case, but it's got to be of such severity, as in Moss. The nature of the interference has to be of such severity, even if a control of use is to demand compensation as part of fair balance. And that is just as rare. As one can see from the case law of, it's just as frequent when you do have a deprivation, that compensation is a part of that fair balance. But it's very, very rare otherwise. It has to be of such an extreme nature as to demand that. And we're not in that territory, I submit, for obvious reasons. I say at this point in the argument, the retrospectivity of paragraph 9 is taken as a given. That's inter alia what I'm trying to justify. And on justification, we make 6 key points. I'll come to go through the 4 stages of the back analysis by way of tie-up at the end, but the 6 key points on justification are firstly that the legitimate aim of this legislation is accepted, but its nature perhaps bears emphasis. It bears emphasis because it shapes the proportionality issues and because it illustrates the nature of the thing that would have to be attacked under justification. In other words, the legislative judgment or set of judgments that have been struck in this Act. And that nature is, in essence, a broad societal justice distribution judgment. The backdrop, as you know, is a very serious set of defects, starting with but not limited to cladding on high-rise buildings above 11 metres. There was then a development of the appreciation of the scale and nature of the issues following the tragedy at Grenfell Tower. Can I invite you to take up Mr. Murphy's statement for this purpose? I'll make this point by lunchtime. If you see, for example, at paragraphs 15 to 17, his witness statement is on page 77 of the Hippersley additional bundle, tab 4. Hope that goes there. So the Hippersley additional bundle, which I think was the one with the witness statement in it. Tab 4, page 77. And the paragraphs I want for this purpose are 15 through to the end of 17. I'm sure that you will have read these. What Grenfell did was, in essence, undermine one of the core and basic safety features of these sorts of buildings, which is you stay in your flat. If there's a fire, and the flat will be contained within the fire, so you can happily stay in it. The problem that Grenfell illustrated is that if the outside of the building goes up, A4 you're right, you've got capping stones on the top that turn it back in, you end up with the sort of tragedy you had in Grenfell, and that leads to the sort of detailed costs and expenditure that would be needed. So 15 to 17, numbers of buildings affected are dealt with at 19 in this statement. And then if you flick forward, still on the numbers, at 25 to 27.
I mean, just carping at Mr. Murphy's statement a bit more. I mean, as of September 2024, can't be relevant on any view. That can't have been in Parliament's mind in 2022. I mean, there were obviously a lot of buildings, but we knew that anyway.
Well, yes, but he can't be criticised for dealing with matters then, because that's illustrative of a large number of buildings anyway.
Absolutely.
You might say that's entirely obvious, but also you're assessing proportionality as of today. You don't have a cut-off date. This isn't at the date of enactment. Why would anyone bother about this? Because the enactment date is what matters. Proportionality, as my little friend positively put to you yesterday, and we agree, is a matter for the court to determine now. Perhaps that might be a convenient moment.
Yes, you're quite right. We've got to 1 o'clock. Say 2 o'clock.
What price of Adrian?